As shown by their engaged questioning of counsel for both sides today, the court is grappling with the practical difficulties and constitutional pitfalls of lawsuits relating to religious employment. Let us hope he is right, because this court does not show itself sympathetic to secular issues. So, the court heard the appeal of a case that turned on the question of whether religious organizations have a constitutional right to discriminate on the basis of race, gender, age, or disability in violation of employment laws. The special religious exemption at issue in this case, called the ministerial exception by those lower courts that have adopted it, has never been considered by the Supreme Court before now. The right of religious employers, as we have said earlier, such as churches and related institutions, to require that employees be of the same religion as their employer and to follow that religion's dictates is unfortunately not at issue in this case. But there will eventually be a case, and it seems as though the Obama administration might be making good on their statement that they will deal with such related difficulties on a case-by-case basis. Burgess further stated, "I remain hopeful that the Supreme Court will again defend the principle that religious institutions are not above the law. This includes our laws restricting employment discrimination, which protect the important social value of equality." We all remain hopeful, but somewhat cynical, as to what such court as the present will decide. There is a public perception, aided by religious fundamentalists and the press, that many American churches run social programs. This is a myth. The statistics are startling. In 1998, there was an important study, the first of its kind in America, called the 1998 National Congregations Survey. Mark Chavez was the principal investigator, and his findings from the result of 1,238 congregations in this country are eye-opening. Overblown media coverage and the political battles in Washington, D.C. have created a false picture of American churches giving significant aid and support to the disadvantaged. Chavez has discovered that most United States congregations focus on the most fleeting contact, if any at all, with needy people. Since the majority of American congregations are small, with 60% of them having fewer than 100 members, there is no real untapped resource for social programs. See Atheist Sociology book list for a review of Mark Chavez's volume, Congregations in America, 2004. The lack of civic education in the United States in the present day is worrisome for the fate of the church-state wall. In 2004-2005, the John S. and James L. Knight Foundation conducted a wide-ranging survey of 112,003 high school students. The foundation was seeking data concerning the future of the First Amendment. 37% of students did not know about the First Amendment, 36% said they take it for granted, and only 27% said they ever think about it. 21% of students did not know what rights it guaranteed. Of those who were familiar with the First Amendment's contents, 35% thought it goes too far in the rights it guarantees. Only 44% of the students surveyed approved of the rights guaranteed in the First Amendment. Many atheist support organizations such as the ACLU, Americans United for Separation of Church and State, American Atheists, Freedom from Religion Foundation, and other groups which work to safeguard and guarantee religious freedom in the United States. Many atheists are aware of the history of our Constitution and are up to date concerning legislation aimed at restricting secular rights, stem cell research, the teaching of evolution in the schools, end-of-life decisions, gay rights, and much more. It is to be hoped in the near future more avowed atheists run for state and national offices, and that non-believers of disparate philosophies join together to create a strong voting bloc. Approximately 20% of the citizens in the United States are unaffiliated with any organized religion, according to surveys. Such a united group of voters could exert significant influence on the direction the United States takes concerning non-believers' civil rights and knowledgeable enforcement of the establishment and freedom clauses of the Constitution. Atheism and the law is a crucial portion of atheist studies. It is only by knowing our history and our rights that we atheists can safeguard them. Non-believers can begin to become acquainted with the cases and the principles critical to our freedoms by reading the books on the book list at AtheistScholar.org. Please also see atheist activism and atheist organizations. It is to be hoped that atheist studies programs will be added to more American colleges and universities with atheism and the law classes prominent. We now close with additional evidence for the founders' intent to establish a secular, non-Christian government. Ed Buckner maintains that the United States Constitution, lacking affirmative references to religion, is the primary and sufficient evidence of the secular intent of our government's founders. The Treaty of Tripoli, written in 1796 by diplomat Joel Barlow and signed and proclaimed by President John Adams on June 10, 1779, adds considerable weight to the issue of the American government's secularism. The Treaty of Tripoli was drafted and signed less than 10 years after the Constitution's ratification. The beginning sentence of the document states unequivocally what religious fundamentalists seek to obliterate. The government of the United States is not in any sense founded on the Christian religion. Thank you so much for your attention.
Thank you.